We start the term with Amanda Kernahan versus Home Warranty Administrator of Florida and Choice Home Warranty. Thank you. Mr. Kott.
Good morning. My name is David Kott. I'm a lawyer with McCarter & English, and I represent the amici, the New Jersey Business and Industry Association, the New Jersey Chamber of Commerce, and the Commerce and Industry Association of New Jersey, which are the three largest business trade associations in New Jersey. And many of their members have arbitration provisions in their contracts. On May 15, 2017, the United States Supreme Court decided kindred nursing. And we believe that the decision of the United States Supreme Court in kindred nursing requires the overruling of this court's opinion in Adelise. Let me start with the opinion of the Kentucky Supreme Court in kindred nursing. In that opinion, the Kentucky Supreme Court said three things. That first, the right to go to court was a fundamental right. Second, for an arbitration provision to be enforceable, it had to have a clear statement that the parties to the arbitration agreement were waiving their right to go to court. And third, the Kentucky Supreme Court said that it was applying a rule of general application. That is, that its clear statement on the waiver of a fundamental right would apply to waivers of any fundamental rights. The United States Supreme Court granted certiorari and reversed. And I want to start with what the Supreme Court said about arbitration. In the early part of its opinion, it says that the primary characteristic of arbitration is the inability to go to court. And that in fact, the, quote, defining trait, close quote, of arbitration is the inability to go to court. The United States Supreme Court then reversed the Kentucky Supreme Court. And it held that the Kentucky Supreme Court clear statement rule, in fact, disfavored, important word, disfavored arbitration, and therefore was preempted by the Federal Arbitration Act.
May I interrupt you with a question? Do you see, if you put Kentucky's opinion and Adelise side by side, they are not in any way identical. And one distinction I can see is there is nothing in Adelise that suggests special contract language for fundamental rights.
Well, there is. Adelise does refer to clear and unambiguous
on
language.
Jury trial, on the right to a jury trial.
Well, no, I think my reading, Your Honor, is that in Adelise, it's the right to go to court. That's 3 or 4 or 5 times in Adelise. That's what, and there's one sentence that refers to jury trial, but Adelise, any
right to go to, but it's limited to the subject matter more than, I mean, the Kentucky Supreme Court seemed to be creating a rule that fundamental rights had a different status in contracts than any other provision. Would you agree with me on that?
No, I think what the Kentucky Supreme Court said is exactly what this court said in Adelise, which is there's a fundamental right, that's what this court said in Adelise, a fundamental right to go to court. This court in Adelise then said there needs to be clear and unambiguous language telling the parties that they're giving up their right to go to court.
But the difference, and tell me if I'm mistaken, the United States Supreme Court was saying to the Kentucky Supreme Court, you have created a singular rule for power of attorneys with respect to arbitration. When a general power is given to a representative, you have created this rule that says you have to say that you're specifically waiving arbitration. You don't do that anywhere else. Adelise, that's kindred nursing. Adelise is nothing new other than collecting cases from 20, 30, 40 years ago about, you can call it waiver of rights in many different circumstances, not just arbitration. They're all cited over there. And they say in those circumstances, whether it's arbitration or whether it's one of those other waiver of rights, the language has to be clear and unambiguous. It wasn't targeting arbitration. It was a line of cases, an area of our law where we treat all of those cases the same.
That ignores 3 pages in the Kindred decision. And in the Kindred decision, the United States Supreme Court held that the Kentucky rule disfavored arbitration.
Go ahead.
And what they held was, and there's a sentence in Kindred Nursing, and the sentence says, the Federal Arbitration Act prohibits state court rules that prevent arbitration, quote, by disfavoring contracts
So this
that
is-
oh so conveniently have as their primary elements the elements of arbitration contracts, close quote.
Because the U.S. Supreme Court thought, despite what Kentucky was saying, that they had singularly targeted arbitration. And of course this is apples to oranges, power of attorney to arbitration agreement. I've read to you the arbitration agreement in Kindred. And what do you say to the fact that when this precise issue was raised brought before the U.S. Supreme Court by, it wasn't like there wasn't a lot of noise about Adelise, the Cato Institute, the National Federation of Independent Business, Chamber of Commerce of the United States, New Jersey Civil Justice Institute, Pacific Legal Foundation, all targeted Adelise. A lot of noise, a lot of publicity. The specific provision, the United States Supreme Court does not grant certiorari. They had their choice, not in a power of attorney case, but in an arbitration agreement case.
The law is settled that the failure of the United States Supreme Court to grant certiorari is not at all a statement on the merits. And Justice Alvin, I want to address something you said, or you asked me,
Go ahead.
which is, what about the Kentucky Supreme Court having a special rule? Aren't they essentially making it up? That, for you to distinguish Kindred on that, you need to ignore the core holding of Kindred, which is that you disfavor arbitration contracts when you say you need clear and unambiguous language of a waiver, because that is exactly what arbitration is.
So let me read something to you, and just tell me whether you agree or disagree with this. Courts should not assume that the parties agreed to arbitrate arbitrability unless there is a clear and unmistakable evidence that they did so.
Well,
Would you agree with that? Or do you think that disfavors
I think
arbitration?
that disfavors, there's no question under Kindred that disfavors
Okay, so
arbitration.
let me tell you what I quoted from. That is the United States Supreme Court in First Options. That is Justice Breyer, who then is quoting any number of other United States Supreme Court cases. I mean, so even in that context, with respect to arbitrating arbitrability, the United States Supreme Court has said the presumption is for a court, and that has to be waived. And I was quoting to you a United States Supreme Court case so you're now arguing that Kindred is overruling First Options and all the cases that First Options was based on.
When you read Kindred, it is clear that the primary holding was that you disfavor arbitration contracts when you require a waiver of the right to go to court, because that is the inherent nature of arbitration. And I want to come back to a question you asked me, Justice Alvin. When you look at the Kindred decision, the first 3 or 4 pages deal with what I just said, and then they say, oh, by the way, and this is me talking, oh, by the way, the Kentucky Supreme Court had a special rule here. But if you look at footnote 1 of the Kindred decision, the last sentence, in discussing that Kentucky having this, by the way, their own rule, in footnote 1 in the last sentence, they say that's just another indication that the Kentucky Supreme Court is treating and disfavoring arbitration, meaning the primary reason that the Kentucky Supreme Court rule can't survive is because of the fundamental nature of arbitration. The question of whether the Kentucky Supreme Court was kind of making it up when they said, we apply this to all contracts, the last sentence of footnote 1 says that's another indication.
But one of the differences, and I won't belabor this point with you, you can respond, is that when the Kentucky Supreme Court came up with this new rule for powers of attorney, it was like out of the air. Okay, there was no precedent for that in Kentucky. Adelise cites, and I won't go through them, all of the other cases outside of arbitration where there has to be a waiver or clear, unambiguous language outside of arbitration, not targeting arbitration for any specific rule.
Two-part answer.
Am I mistaken? You've read Adelise.
Yeah, two-part answer to that. If this court says kindred is distinguishable because Kentucky Supreme Court made it up, to do that, you need to ignore 4 pages with the core holding that I just discussed. That's the first part. Second, I don't accept what's stated in Adelise that we have in New Jersey as a rule that there must be an express waiver of the right to a fundamental right. And I'll refer to this court's opinion in Stelluti versus Sesabon, which is the gym case involving a customer goes into a gym and he signs a waiver and then gets injured. And the court, the whole issue in the court was, is that going to be enforceable? And in that decision, which involves precisely the right to go to court, there's no requirement when the court lays out what these agreements need to be enforceable.
We weren't talking about the language.
No
the
requirement that the parties to that contract state that they know they're not going to go to court.
Tell me how many of our cases you want us to overrule. Marchak, Martindale, it's one to understand.
Morgan, Your Honor.
Garfinkel.
Morgan.
The answer is, if the United
and all of the other cases that are in parentheticals, all of the other waiver of rights cases.
The answer to that is if the United States Supreme Court
and first options.
Okay, if the United States Supreme Court has said that the rule that this court's articulated in Adelise and the others disfavors arbitration and therefore is preempted, then obviously, and I think we're back to first-year law school basic jurisprudence, if that's the rule that they've enunciated, and they have, that does require this court to overrule not only Adelise, but all the cases that have the similar holding to Adelise.
So in light of the supremacy of federal law in this area, tell us succinctly why kindred nursing, a case that deals with the power of attorney, the logic behind it extends to arbitration.
Well, I don't think it really matters, Chief Justice Rabner, that it deals with the power of attorney, because the entire kindred decision is analyzed based on arbitration law and is analyzed as if it's an arbitration contract.
That's precisely what I'm asking you to do, is explain why you believe the logic of kindred nursing extends beyond.
And I believe that the logic is because they talked there about you can't have any court rule, that is court-made rule, that disfavors arbitration, and as soon as you have a rule that says the parties to the arbitration clause must be informed that they're waiving their fundamental right to go to court, that as a matter of law disfavors arbitration because of the essential element of arbitration, which is you can't go to court, and therefore is preempted. That's the holding of kindred nursing.
But there's a bit of a circularity going on here, because you don't seem to be arguing that there doesn't have to be mutuality of assent, that parties need to understand what it is they're agreeing to. Arbitration exists only when the parties agree to arbitrate.
Agreed.
So we're back to the essential definition is what is the agreement to arbitrate? And if there is a public policy in our Plain Language Act and in our line of case law that says we want that understanding to be clearly and unambiguously expressed in the document that creates the contract between the parties, then we're back where we started from. Kindred doesn't answer the question of whether there is sufficient clarity in any particular contract, like the one we're looking at today, in order to satisfy the mutuality of assent.
Justice Levecchia, there are two issues in this case. One is whether kindred overrules the line of decisions requiring a clear and unambiguous waiver. That's one issue. Second is the issue I think you just raised with me, which is what I would call meeting of minds, old-fashioned contract law. Did these parties have a meeting of the minds that they were going to arbitrate? All those factors you had, meaning, and you've discussed with counsel, font size, wording, all of those things. Those are separate things. So if I'm right that kindred overrules your decisions, you still have, as our law, meeting of the minds. And I think I would say it this way, we're back to basics.
So if this court were to hold that a particular contract does not meet the requirements of ordinary contract law without articulating a special requirement of waiver language when the particular clause at issue is an arbitration clause, your kindred argument is irrelevant. Is that correct?
Precisely, and I wish I had phrased it that way, Justice Patterson.
I have two really short questions. Is it your contention that kindred essentially stands for the proposition that when you say arbitration in an agreement, everybody knows what that means? And what that means is you give up your right to go to court?
No, that's not my position.
Okay. And then you answer my second question.
So, in summation, Chief Justice,
Okay, so off on that. So you agree that the term arbitration standing alone is not self-defining?
well, I haven't really analyzed it, and I don't, because that's not my issue.
Okay.
But I would say that if you overrule your cases, meaning Adelise and the others, overrule the requirement of a clear and unambiguous statement, we're back to old rules, and we're back to the general rules, which is, was there a meeting of the minds?
Do we have to even reach kindred nursing in this case?
I think you do, because counsel asked you to reach it. She is arguing, if I understand her argument, I think I do, at the end in the colloquy with, I think, Chief Justice, she is arguing that kindred requires that the Adelise clear and unambiguous language not be required.
That's not what I heard counsel saying, that her contract is good under Adelise.
Well, she might have said her contract's good under Adelise, but that doesn't answer the question whether this court's opinion in Adelise is now no longer good law.
I
But I
understand
asked
that.
her that question and she answered it as a no.
Okay.
I think what her statement, obviously she's going to be back on rebuttal to speak for herself, but I think her statement was she was not saying Adelise per se is preempted.
I am saying that.
I
Clearly.
got that.
Clearly.
And, but that the appellate division in some
Yeah.
portion of the opinion.
Patterson, to answer your question, I don't know how the court could render a decision here and say the contract is okay or is not okay because it doesn't have the language of waiver, and not reach the issue of whether kindred requires overruling. Let me try it another way.
That's not quite the question, though, because we're talking about it. You urge that this court go back to ordinary contract terms. If, in fact, the court reached a decision in either direction based upon ordinary contract terms and clarity and mutual assent and all of the bells and whistles that accompany that, why would that require a kindred rule?
It might not, as long as the decision did not require what's required in Adelise, which is a clear and unambiguous statement that the parties are giving up their right to go to court. If it's just a decision that says, normal rules, was there a meeting of the minds here based on font size and all the other things that the colloquy the court had with counsel, then I'm not sure you need to. However, I would say as a matter of jurisprudence, there are a lot of these cases kick around because, as I said, a lot of businesses have these provisions. And it would be unfortunate to not have this court reach this issue now and then reach it in 3 years when there's 30 cases in the appellate division applying Adelise.
Asking you as I'm sorry, go ahead.
I know you represent a lot of businesses. Wouldn't you say that most of them have in some fashion or other, you kn- however they state it, you're not going to the courthouse if you sign this arbitration agreement.
Well,
Like the language, the language in Kindred, that one is really expansive. But most arbitration agreements, in some manner or other, indicate you're not going to get a judicial forum if you sign an arbitration agreement.
some do and some don't, but we, in my 3 clients here, we have as members smaller companies who don't have armies of lawyers, both inside and outside. And they may be pulling forms off a computer. They may be pulling a competitor's forms.
So, you know, at some point or other, particularly if you're a New Jersey company, are you required to, like, read one of the cases of New Jersey Supreme Court? And then if it says, in some fashion, no magic language, you got to indicate you're not, this arbitration, just indicate to the common consumer, you're not going to be going to before a judge or a court
If
in
I
some
were-
fashion or other.
if I were
Is
talking-
that so difficult?
Yeah, if I were talking to one of my clients, I would say you need to do that because that's what the New Jersey Supreme Court has said you need to
Right.
do.
You're not telling us that the bylaws don't say they have to read Supreme Court cases? Anything else, Mr. Kott?
Check the statutes.
Yes, I thank the court.
Thank you.
Thank you. Mr. Keefe?